The 8A program is gone. I understand people are very scared about that. It's a lot of questions at the moment. Hey, I'm in the 8A program. They get this preference. I don't.
What does she gain from this lawsuit? Why not just form a joint venture?
It's really hard to win challenging the government on that. SBA could then rewrite the regulations. They don't want to cause problems that could make things even worse for them and worse for the program down the road.
All my amazing GovCon winners, we have Senior Associate Attorney John Holt, because who's better to talk about what's going on with the whole 8A program and Halton applications than a real attorney. So John, welcome to the channel.
Thank you. It's a pleasure to be here.
It's such a pleasure and honor for you to be here today. And let's just jump right into it. Talk to us about the whole 8A situation. Some people think this is connected to Supreme Court judgments and Supreme Court decisions. Some believe that this case is representative of people trying to take away things. Please break down what is really going on with this whole 8A situation.
Certainly. So, yeah, and it's a great mention of that Supreme Court case, the Students for Fair Admission matter. I will say that this case, and it comes out of Tennessee, and the case's name is Ultima Services Corporation versus the U.S. Department of Agriculture. And the case, it does mention, the judge did allude to that this Supreme Court decision, but it's really based in, it's actually a Sixth Circuit decision, which has analysis basically on, the Sixth Circuit kind of has its own analysis on how strict scrutiny is applied. And we'll go into that a little more details. But basically, that system is used by judges in this country to determine how can a program be tailored in certain ways to alleviate racial discrimination, as well as even in the past, in older cases, it was even to determine when it was used in negative ways. But basically, the idea there is that when it comes to things like racial-based policies and things like that, the government has to show a compelling, like a very great interest, and it has to show not only that, but that its policy is narrowly tailored, and which means it's really clean cut. It doesn't do too much more than it needs to achieve those goals. And that was kind of the issue in the Ultima case, as it was in the Supreme Court case. But the Ultima case's analysis was based on some findings from the Sixth Circuit, which that Tennessee court is in. And there it noted, and we'll get into it a little bit more, but it noted there some of the issues were that it was based on the 8A program is not based on specific findings of discrimination as opposed to national, more generalized statistical findings, which in turn admittedly is also kind of based on some Supreme Court language in the past. But basically, yeah, it was mostly really on a Sixth Circuit level that decision arose.
And talk to us about what does this mean? Because it seems like they've halted applications. People are kind of freaking out. And the timing, in my opinion, is horrible because it's the end of the fiscal year. And I know that there were many even waiting to find out if they were to be awarded an 8A set aside.
Yeah, we do agree that the timing was really terrible. It would have been nice if the court could at least wait until after the fiscal year to get this out if it was going to make the decision it did. At the moment, what we know is this, and we're still waiting because from what we can tell, SBA's kind of been waiting too. And I will say also that though this court decision was made, it is doubtful that this means the matter is over. Obviously, they can appeal it to the next level, which would be the Sixth Circuit Court of Appeals. And then, of course, if it came to it could even go in front of the Supreme Court. And that could be a realistic possibility, especially considering that there's a government agency involved here. That's just usually in our experience, you're going to see that more likely to result in the Supreme Court being willing to hear such a case. But at the moment, what we know right now is this. First of all, the rebuttable presumption, there is an injunction on it. And we do know that. And that's the decision of that court, which means that the SBA definitely couldn't still apply that rule where if you're a member of a racial minority and that's listed in that regulation, that you would get that presumption of social disadvantage, which basically meant that you could, in a sense, skip that step and you didn't have to submit a narrative and things like that. SBA had a few options here. They could have just switched to immediately to everyone and submitted narratives, things like that. Then they may still go to that point, depending on how things go. For now, they decided to put a pause on the application process. We don't know. They haven't unfortunately given any specifics on how long this will be, and it's not too surprising considering just the nature of how things are with the court case. There's even a further hearing hearings still going on for that court case, which is supposed to be on August 31st. So again, SBA is just playing it very cautious right now. And yeah, I agree, it's really unfortunate. But at the same time, from the perspective of SBA, I don't necessarily blame them too much, because they don't want to cause problems that could make things even worse for them and worse for the program down the road. So we'll say, though, at the moment, there's nothing to suggest that this means that the 8A program is gone or something like that. I understand people are very scared about that. This decision does not hold that. It simply just holds that the rebuttable presumption is enjoined against at the moment. And again, that may change in the future.
And I know when I first applied for the 8A, it was 2011. Seems like yesterday. I had to write a narrative. I had no idea that they had dropped that narrative piece. So by them reinstating it, for anyone who's watching or you're waiting for everything to open back up, the narrative piece, it is what it is. Because at the end of the day, you have to provide evidence and support. You can't just say, I've experienced adverse situations. So I think whatever happens, if they make that a mandate, it really won't be that big of a deal.
Yes, and our thinking is it kind of always depend too on how in detail your narrative use had to be. For example, we've found in cases where people were claiming that they were had experienced social disadvantage in the forms of discriminatory treatment in their career and their education on the basis of disability, that it generally is required a bit more, just especially depending on the nature of disabilities, especially I'd say in the case of something involving mental disorders or learning disorders, is kind of the case as everyone is learning more about what those disorders do to people and how it affects people and how people cannot control, a number of those conditions in the way that, we used to think. At this moment, there's still a little bit more kind of, I wouldn't say suspicion, but, they just are a little more incredulous, maybe would be the word, on those sorts of claims. So in general, we've seen that the narratives had to be a bit more detailed in terms of, hey, I experienced this, you had to show more. Our thinking is with this decision, which basically makes down that narrative going to be for everyone, because there's a practical factor there in that now SBA has to review all those narratives. If, again, assuming this rule stays in place, they may relax a bit on what they expect out of those narratives in terms of the level of detail, the level of length, that sort of thing. How they'll apply that, I don't know. And again, this is really kind of speculation, but just based on understanding of how it goes and how busy they are and understanding that they're people and they can't spend all day, every day doing only that. They have other obligations too. I think that's something we could see. Again, it's a lot of questions at the moment, but SBA develops things. They will, of course, let us know, and they will get the word out, and we will be happy to share it.
And that's good to know. I mean, hey, and they're always welcome to outsource it. There's plenty of us government contracting companies who would love to have that as a contract.
Absolutely.
Putting that out there to manifest. What do you suspect may be the outcome in this situation?
I will say this one's kind of tough to say. I read over the case. Some of the arguments the judge made, I would say, were kind of suspect. Especially, I am a bit skeptical on the argument that statistical discrimination doesn't suffice for showing a specific form, specific examples. I get that to a degree, but I would say what it shows is that in the aggregate that there is this sort of discriminatory pattern and these discriminatory actions. One thing that the judge did raise as an argument, which I admittedly found was a fairly compelling argument, was that the issue was that the rebuttable presumption really was less of a presumption and more of a just automatic. If you met that, because there's no real way to challenge the presumption. There's no way for a third party to say, hey, that person shouldn't be in an 8A program. And I thought that was a fair argument in that it made it less narrowly tailored, and it made the policy just a bit stronger than it could, maybe potentially be otherwise. Now, what would the alternative be to that? I don't really know, but the argument nonetheless, I did find at least, that there was a fair argument at that point. So, which leaves us then at the question, what will the outcome be? It's really hard to say, especially in considering the Supreme Court's recent decision on the matter of affirmative action. Obviously, the court is a little more on the conservative bent at the moment, and so I would say it'd be a little more likely than it used to be that they would uphold this decision. But at the same time, there's also the practical side in that, especially considering Roberts' court, they do like to somewhat side with the government in certain things, keep kind of the system in place as it is. They don't like to cause waves, especially Roberts. He's very much known, I would say, for sort of stability. He's more interested in stability than necessarily ideological thing. So we'll see. I would say, I think at the moment, I would suspect that it would be upheld at the Sixth Circuit just because it's based on the Sixth Circuit's own decisions there. And if it then goes to Supreme Court, I'm not sure. And also, there's also the option that, SBA could then rewrite the regulations and still find a way to, incorporate the preference for people who are members of racial minorities while doing it maybe in a different way than it's done now. And that's obvious. That's always an option there. There's some very creative minds in terms of rulemaking there in the government. So we will see how that goes. But at the moment, I would sort of suspect that it will likely be upheld, at least in the next level, but it's really hard to say. This is definitely one where it's not a case of like, oh yeah, no, this is going to get shot down or something like that.
And this is just a Kizzy thing. From my understanding, the business owner, she had this work with the USDA, and then it seemed like it was ultimately moved away from her for whatever reason or not. I read some things that said she was no longer considered small, and who knows, couple of things. One, what does she gain from this lawsuit? Number two, why not just form a joint venture? Why not just form an 8A joint venture? Because you could have formed an 8A joint venture even if she was large. I don't know. Never met this person or anything of that nature. And you could have this 8A joint venture and this would have all been resolved. I'm just wondering about these things.
No, and we would agree. And of course, I don't want to comment entirely on her situation. I don't know the full circumstances, but it is a curious thing in that, yes, if size was an issue, of course, then she would have had to enter a mentor-protege relationship in which she'd be the mentor. But again, I think that would be something very doable in their circumstances. And obviously, I think a lot of 8As would have jumped, I would say, to joint venture with her because she was the incumbent. That would be a huge advantage in getting the contract. And so I think that I do question sort of the practical stance of it. I don't want to comment on her situation, but it seems like, she kind of, just went in guns blazing at something when maybe could have been a more simple and practical step that could have been taken. Now, of course, the court, for its part, has to simply look at it as, yes, this was removed, that she lost a contract because of this move to the 8A system, and it has to look at it solely in that perspective. But yes, from a practical perspective, we made it's a bit of a curious decision when, there were some alternatives there. Was it maybe emotions or something like that? It's hard to say. But yeah, I do sort of question what the reasoning for going after the full thing was when there was, again, smaller in scale options, we'd say, for addressing her issues and something that she could have done with. And also probably, saved, I'm sure, and I'm an attorney, as much as I keep it down a little on the down low, we do cost money. And I imagine she's had attorney's fees from this. And even with the decision in your favor, that there's still going to be costs in the long run. So yeah, it's hard to say what her decision making is there. But yes, those are both great points to make, that the joint venture program system and the mentor protege program were really available options there for her that she should have considered maybe, to make it easier for everyone, but it's what it is, unfortunately, at the moment.
So interesting, and I can't wait to be able to share more. And so this is a great segue to talk about a couple of topics. Alaskan Native Hawaiian organizations, and joint venture. So if someone is in the middle of forming an 8A joint venture with a company who has an 8A, will they run into any issues with getting sole sources through that joint venture?
At the moment, and again, we'll have to see if there's any developments to change it. I don't see anything in the holding or anything like that would affect that. There's nothing that suggests that 8A status, current participants, will lose their status or anything like that. And that joint venture system of you join with an 8A, it doesn't really have anything to do with any situation where that participant or anything that to make that joint venture, there's this they have to show, some sort of, discrimination or anything. It's just that once you have that 8A status and someone wants to joint venture, you joint venture, right? Assuming all the, the small business, all those requirements are met. So at the moment, I don't see anything that would cause an issue for that from this case. Again, that, maybe things change in the future. You never know with how court cases can go. But I don't see nothing that the case held or any of its effects suggests that would be an issue. issue. I think that if someone wants to joint venture, it should be fine, presuming all the other situations, all the other requirements are met. And again, though, I will just have to say as a caveat, of course, as an attorney, anything I say here, please do not take it as specific legal advice to your situation. It's just general observations. If you do have a specific question, you can contact us. I'll be able to get that information at the end here. Or, you're an attorney in your area or anyone who specializes in this field.
No, I love that. And I appreciate you sharing that because this is just to provide information. This is not legal advice. So in terms of Alaskan Native concerns and Native Hawaiian organizations, it seems if I was either of them, if I had an 8A and I sold majority ownership to a Native Hawaiian, so I have a colleague who did that, I don't know if I'd really be too concerned about this.
Very important kind of consideration when it comes to law and for attorneys is that we obviously look very closely in between the lines and try to determine, how broad the scope of a decision is. A decision can be very narrowly tailored, which means it just applies to, one little word even in a statute, or it can knock out whole statutes and whole areas of law. It always depends on the decision. And then what's important here is that the judge specifically said simply that the rebuttable presumption in the regulation, and for the life of me, I just couldn't remember what the number of that regulation is, and I'll find it here. But that rebuttable presumption alone is enjoined against. Said nothing about the matters with the tribes, Indian tribes, Alaskan Native corporations, Native Hawaiian organizations, anything like that. There was nothing that specifically said that, even though I could see someone bringing a case based on this case that brought that argument, but the issue is that at the moment that's not been brought, and the law takes that very seriously. Is just because the case held this about this part, that does not necessarily mean it's established that the other parts are affected. So at the moment, we do think, based on what we've read here and based on what we've seen in that decision, is that in those situations, we don't think the decision affects it at the moment. Again, this could very much change, especially like I said, someone might bring a case on the same basis. And it also might depend on, if it gets appealed, what the appellate court might say. They may broaden it. They generally don't like to do that, but it's just always something important to consider. So at the moment, we would say, there is nothing, I wouldn't say nothing to necessarily, I would keep an eye on this stuff. But I don't think it's something where it's like you need to hit the panic button in that situation.
I always wonder if someone potentially, and maybe there's not a way to go about this, I don't know, would really question or file a lawsuit around ANC, tribe, Native Hawaiian organizations that are able to get $100 million DOD, sole source, no question asked, and I believe $25 million on the federal side. In that, why isn't this a blanket policy for all of us in the 8A? Why can't I just keep spinning off 8As? I graduated from the 8A program, but why can't I keep spinning them off?
Again, this case does open a little bit of a door on that. That was kind of the argument of this person is, why can't I get into 8A when, why do they get automatic preference, that sort of thing. And that could be an argument that is brought up with this. Again, I will say, because of the nature of that argument, and that's the way that's styled in that way of, hey, I'm in the 8A program, they get this preference, I don't. I would imagine there's very few 8A participants that want to, because of the way that could impact the program as a whole, which is, I know is, in my experience, is most 8A participants very pleased with the program. So I imagine it would, in practical perspective, it's one of those things where, you have to take into consideration of cutting off the nose despite the face sort of situation, where, you may get a little bit of advantage, but in the end, it turns out, you brought the whole thing down, and now it hurts you really bad. Yeah. That said, it is something that could be brought, and it could then, of course, as kind of alluded there too, brought by someone outside the program as, again, one of these things of, why do they get this benefit? Why is it automatically presumed, that sort of situation? Now, I would imagine, because the 8A program, and it kind of getting into some deeper concepts in law here, because it's not actually protesting. They wouldn't actually be protesting a racial classification. I said they'd be protesting is specifically that there's a benefit that goes to this part of the 8A program as opposed to that sort of thing. I imagine they'd have a lot of difficulty there with standing in that sort of situation because they couldn't show that they were being harmed because they're not in the 8-day program anyway. So that would be a consideration there too. But it is interesting, and those things could arise again. And this is always obviously very developing areas we've repeatedly noted here. But I would say, just for my guess, is that most 8-day participants probably wouldn't want to press the issue just because what gain does it get them? And a lot of loss is a potential there. So
yeah, I could definitely see that. I mean, as a graduate of the program, it did change my life. It took us from a couple of people to we now have about 100, depending on some of our contracts. So it's changed everything. I graduated a couple years ago, so it's a great program. But what about these other set-asides? Should we be concerned in terms of hub zone or service disabled or with the woman-owned program? Is there going to be someone who says, I'm really a woman and I should be in the woman-owned program, and now there's questions about gender? Or if somebody's in the woman-owned program, but maybe they change their gender, do they lose their status?
Mm-hmm. That is actually one I have thought about recently with how with the current things issues with gender and gender identity, how that could impact that, because that is actually a very good question. And I'll be frank, I have no idea how that would go over in terms of the courts. It obviously would depend a lot on the court, probably if it was brought in front of and the appeals and things like that. But it raises some really great questions in terms of what would the court see that as, like, oh yeah, that makes sense. In terms of that's the purpose of this is, this anti-discrimination, sort of program versus specifically to benefit, biological women or something like that. And it's a really great question. I will say when it comes to challenges of the set-aside, a lot of the set-aside programs, I do not foresee this being an issue. First of all, when it comes to hub zone and SDVOSB, VOSB, so your hub zone and your veterans matters. Both for hub zone, that's based on where you live and sort of an economic sort of things. The thing is that only is going to be a rational basis test because there's no discrimination laws. There's no concept of that being, something that is going to be looked at closely. It's not protected. It's not a protected status of what class you're in or where you live. And so for someone to challenge it, they'd have to show that that the government just doesn't have a rational interest in it. And the odds are it's really hard to win challenging the government on that because the government just has to say, look, this is our policy interest. And as long as the policy interest isn't basically off the wall insane, courts are going to give them the deference. And so and the same thing goes for veteran status. Now there are, in some states, I understand, of course, that veteran status is a protected thing, but when it comes to the federal government's, the law that's been established on it, that would again just be probably a rational basis test, in which case, all the government has to say is, look, these people fought for our country and we are trying to benefit them. And the court says, yeah, that's pretty reasonable reason to have a rule. And so I would be very surprised if anyone brought, I'm sure there's people who love to challenge it, but if there's any attorneys that who understand the law well, they would know that that's not likely to be a winning case. Again, could anything happen? Sure. But just on the basis of how that law is applied, we would think that those two programs probably pretty safe from any sort of challenge on that basis. Now, on the women-owned small business thing, gender and sex-based laws, there is kind of this middle levels of scrutiny that courts apply. So the highest is strict scrutiny, like I mentioned earlier, where government has to show it has a compelling interest, and then it has to also show that it's narrowly tailored. What is used for gender and sex-based is the middle ground, is intermediate scrutiny, and it has to simply show that the law being challenged, the government just would have to show that the law being challenged furthers an important government interest by means that are related to that, reasonably related to that interest or substantially related to that interest. It can't just say, hey, this is our policy interest and it's a good policy and win. But it is an easier thing than, it doesn't have to show that it's super, narrowly tailored. It can be a little broader in impact than, some other alternative policy, and it could still pass. So whoever would challenge the women-owned small business program or any aspect of that on the same on this sort of this basis from this Ultima case, it's going to be a much more difficult climb for them, just because the standard the government has to show is less strict, I guess, for lack of a better word. It doesn't have to show as much. So could it be a possibility? Yes. And I think, it would be a case that would be stronger than one for, like, say, against the veteran-owned or hub-zone one, which I would say is a case that have very little chance at all. But I'd still think it would have a real tough time, because the government only has to show that, hey, this is important interest. I think it would be able to do that, and it just has to show that the means it chose go towards that interest. And I think it's pretty clear that the program that favors, women-owned businesses supports, alleviating discrimination against women. So I would say that it would have a difficult time. So I would think at the moment, the other set-aside programs are probably pretty safe. Again, if that could change, and keep an eye on SBA and they would let you know. But I would not keep too hard of an eye on it, as much as if in the case of 8A. So.
And what suggestions can you offer to those who maybe they were in the middle of applying, or they were just about to apply, or they're waiting to find out if they're going to get this 8A?
Yeah, we've had a couple clients where, unfortunately, I've even had to tell one prospective client, before they did anything, because I didn't want them to spend the money, and then I'll then tell them, hey, because that wouldn't sound very good.
That'd be fun. That's why you're here.
Exactly.
Because you're amazing and you're ethical, but also beware. For those of you watching, not everybody is like that. They have no problem taking your money and then saying, oh, by the way, or even a PTAC or an Apex. And although they don't take your money, just be aware that this isn't just applies to some people. This is across the board. So as you were saying.
Yeah. So for now, what we would suggest right now, it looks like, if this is all upheld, that a narrative, everyone has to do a narrative system would be in place. That is something to consider maybe working on at the moment. Obviously, I will say, of course, when it comes to narratives, historically, they take a fair bit of time when we've worked on them. So I will say one thing too is, we can assist, of course, with that, but we also understand, of course, because, we're not free, that cost can be a consideration. So, and we would suggest this with any part of any application for 8A, WSB, whenever. If there's parts where you feel very comfortable and you look at it, you're like, I can do this, go ahead and do that. We can always, an attorney can look it over and stuff, but we always suggest, if you feel you can do it and you feel very comfortable with it, and, if you even just want to take a look, that's fine. We don't want anyone feeling like, oh, I gotta, have every single thing done by an attorney. Yes, if you want to do that, that's great. We'll be, attorneys like us will be happy to help, but we also understand a cost consideration. So if there's parts where you feel like, hey, I can describe this pretty well, and you guys can just take a look or something like that, we recommend that people do that, just to make sure that, because your interest comes first. Obviously, yes, we want business. We want to, we're going to do well on that. But at the same time, what I really want is to see people, get the outcome and feel like, hey, I was treated well, and that I got what I wanted at the least cost to me, basically possible. So, but I would say regardless, definitely look at, working on a narrative, something like that, just being ready in case, it is upheld. And, if you do work on it and it turns out, hey, this gets overturned and, it goes back to relatives, yeah, you may have lost a little time, but hey, the situation is still pretty good for you then, because then you could go right back to the application mode. I will say too, if I would treat it, if you had already submitted application, I would just treat it as the situation as when everything's kind of settled, that I'll still have to apply again. It may be that they just pick it back up again, in which case great, but I just don't want someone, saying, well, I don't need to do anything more. I'll just wait for it to start over again, start up again. And all of a sudden, they're caught flat-footed and, oh, I have to, I'm going to have to do this all over again. And now I'm behind and I have this procurement coming where I wanted to. So I just want people to avoid that. So I'd say take a proactive stance on it and just wouldn't say assume the worst, but just assume precautionary things. Be cautious with it and assume, hey, it's going to be whatever, it's going to take a little more work or something like that. Assume that may be the outcome. And that way, at the end of the day, worst case scenario is you put in a little work, but you didn't need to, versus, oh no, I'm really out of, I'm really out of it now, and I'm in a really bad spot. So that is my suggestion at the moment. And like I said, keeping an eye on I would keep in good contact with SBA. If you have an SBA rep, if you're applying, if you have anyone in SBA that you're in contact with, we are always, of course, able to happily answer quickly, any general questions about rules, like any changes, Our blog, www.smallgovcon.com. We regularly post there updates on rules and things like that. And this obviously is something that's so substantial that, we are keeping such a close eye on it that the moment we learn something, we would share on it on there too. So I would say taking a proactive approach and, making sure your kind of ducks are in a row for if a narrative is needed and that, you have to apply again. That'd be a good approach. And then also just keeping a close eye on things. Those are the two things you have reasonable control right now that you can do. Other than that, when it comes to the decision of the courts, it's up to the courts at the moment. So
no, and that's great advice, because even after this outcome per se, a gentleman who I'm coaching, he still received information in the certified portal where they requested information to progress with his 8A application.
Oh.
So it was probably a couple days after it happened.
I think the decision to kind of put a halt to things now came a little later, but it's all the more reason to always pay attention and don't assume that, oh well, they said this, that means it's out. Things can change in a very quick amount of time.
So make sure you're still checking that portal. Be ready. And what are some things that go into the essay? I recall when I put together my essay, the company I hired, I had somebody helping me who had a background in writing, and she was able to really take the experiences that I had to progress with my application, which was, of course, approved. But what are some of those things? Because there's probably people thinking like, oh, I can write an essay, but from my understanding, it has to be based around you as a business owner, as an entrepreneur, not like when you were 7.
I will say, even stuff from childhood that can be relevant if it affected your education and the quality of education and the outcomes of it. But yes, this is not to, say, oh, well, that if someone's treated you horribly in the past, it doesn't matter. It does, of course. From just a pure moral perspective, but from the perspective of the program, the fact someone was a jerk to you, a few times, or even on a long-term basis, it doesn't matter too much for the 8A program's perspective if it didn't affect your ability to get, it didn't affect how your education turned out, it didn't affect your career, it didn't affect your ability to get, credit or things like that. That's what they're looking for. So, and we see it a lot is that, and understandably, people who have had to do the narrative, they'll ask, like, hey, I had this go really badly for me. This guy was really jerk to me. People were mean to me at work. And, obviously that's terrible. I'm sorry you've been through that. But then, we look into it like, well, how did it affect, did it affect their ability to perform at work? Did it affect their evaluations? Were they fired? Was it anything? No. And fortunately, in the sense that I'm glad it, it didn't affect those things for them. But from the perspective of 8A, it doesn't add much then to put that in your essay. So what they're going to look for is things where you can show, hey, I was treated badly. And that bad treatment resulted in me having less opportunities, having less, access to credit. I didn't get this promotion, which, I would have made my career different. Or I was told, hey, I can't do that. And so I didn't go to the school I wanted to go to. Those are the sorts of things that they're looking for. So I would tailor it towards that. When you're writing your essay, think about the times that actually it made like a material impact on your plans for your future and those sorts of things. Again, you can mention, of course, there's other times it's to help kind of support just kind of the general what you went through and stuff. But those are the things that really make and break the narrative is what happened to me that I can say, hey, I'd be here if it wasn't for that. Or I would be, at this point if it wasn't for that. That's what we're going to look for. as attorneys, of course, we do a little legal writing, and a lot of that also gets to be very, technical and things like that. They are looking at it's going to be a little more, again, like a narrative. It's going to be a little bit more personal in the nature of it. And that's something too, obviously, of course, that you will want to discuss also if someone assists you with it, because some of this stuff I know can be very difficult to talk about, and understandably so. Be understanding too, also, if we ask these questions too about it, and we're not trying to be jerks. We're trying to do it because we want to make sure we write it. We want to know, because if it doesn't help you, we don't want to do something that could, either doesn't help you, or even, in some case it can hurt, certain applications. If it's, it's like, because all the quote unquote good stuff gets kind of covered up by all the other stuff. And again, you have to remember that a lot of these reviewers, all of them are human. Some, and maybe some, we don't know.
Never know. They could be using Chat GPT.
Right. Oh, that's true too. I was thinking maybe more with the aliens and stuff, but
both. It could be aliens and Chat GPT, or aliens are behind Chat GPT.
That is always a possibility too. But it's a good thing to remember, is that you want to tailor it in a way that you don't want people kind of get lost in which is also why it is good to get someone who's, if it's a viable option. Again, we understand cost purposes is not always a viable option, but if it is, to have someone who is well trained in even a bit creative writing, but legal writing too, and things like that. And I will say, at least to write a little bit, I've been told I do pretty well both. But again, that's just for the year there.
I would say you do really well. I mean, I hired John and the firm to help with joint venture contracts and things of that nature. And I've been beyond thoroughly impressed, because I don't just bring anyone onto my channel. That's really important. And I will continue working with John until I die. So that's not going to be for a long time. So sorry, y'all. Don't be for a long time. I'm going to be out here. But writing is super important, and especially because it is emotional. As you were talking, it triggered some of the things that I talked about for my essay. There were some things that happened in graduate school, which then cost me scholarships and added on to my student debt amount and things of that nature. So yeah, you definitely want someone to help, because especially when it's emotional, we get caught up in the emotions, and it can be hard to put it on paper where somebody can really understand and you can provide all of that information. Because I just see this whole notion around evidence and facts, and that's vital to his point earlier about you experience something, okay, but how did it have this impact? So just be prepared, because it doesn't mean you always have to have some kind of evidence like, this happened and here we go. I mean, it's not like you're trying to get a photo for the gram or something, but just realize that this is the kind of information that you're going to have to more than likely put together, whether you hire someone amazing like John or you do it on your own. Tell us about the blog again for everyone.
Oh, yes. The blog is www.smallgovcon. That's SMALLGOVCON, all one word, .com. And there we post regularly about not just the 8A program in itself, but anything in federal government contracting. We'll post about other cases, protests, rule changes, particular solicitations that are of interest. So yeah, it's a great resource. Again, we post there, I'd say, at least a few times a week. Sometimes if it does get really busy, maybe post only a couple times, just because obviously we put our clients' interests first, and as much as we want to get the word out there, we do have a duty to our clients that we take very seriously. But at the very least, we'll get something out, even if it's just a thing going over a little review over some principles in the rules. So, but yeah, no, it's a wonderful, and we do have also, I'll try to get some information on this, but we do have some handbooks as well that have basic guides on things like the joint ventures, 8A program, though that one we may need to update depending on how things go, and things like that. So, and of course, you can also always reach out to us. My email is jholtz, HOLTZ, at coprince, KOPRINCE.com. If you just have a general question, and like I said, and if it's something where it's like, hey, it's specific to your situation, I'll let you know. It's like, hey, we can talk like a phone call about it, a little more detail, but I won't be able to give specific advice, but just so people know that if they're like, oh, that means I can answer, a specific question, not unless you're a client, unfortunately. And that's not just because, hey, we want the business, but it's also to protect you because we want to make sure that those attorney-client privilege rules are in place before we discuss any particularly sensitive stuff.
And also keep in mind, this is for assistance around government contracting.
Yes.
If you have other legal needs, you're going to look into somebody else. Just put that out there for everyone watching. And it's really important, in my opinion, based on my 15 years of being in this space. It's super important to seek legal counsel, especially for joint ventures, 8A, or, if things of that nature, because anytime there's a dollar involved, there's potential for things to go sideways.
Yes.
And for those of you, who are unable maybe at this point in time to afford any legal assistance, don't worry. You have the blog, you have the books that they have. There's so many different resources out there, and just keep coming back to this channel. And I'm just so grateful and so thankful to you, John, for taking the time to be here. I really appreciate it. And we'll all keep checking back to see what happens with the 8A, what happened, who knows, with the woman-owned set aside. But until then, you all know you're amazing and everything is possible. So thank you all.